Right now, there is no enforceable parental notification law in Illinois, and there hasn't been actually ever. We have had laws on the books since 1975 requiring either parental notification or parental consent, but at every stage we have been successful in obtaining court orders that say that the state may not enforce the law because it violates initially the federal constitution, and in this current litigation, the state constitution. We are very hopeful and confident that we will be successful in this litigation in having the law permanently enjoined. We believe that this law really does in fact violate a number of the provisions of the Illinois Constitution, and the court has already found that we've raised a fair question of the existence of our clients' rights under the Illinois Constitution, as well as our likelihood of success on the merits here. And we think that we will continue to prevail and that this law will never go into effect. We actually sometimes fondly refer to Illinois as the hole in the donut. We are the only state in the Midwest that does not have a mandatory parental involvement law, either parental notification or parental consent. We actually have many fewer reproductive health restrictions than any of the states surrounding us, and so the hole in the donut comment actually applies to other laws as well. But we are the only state in the Midwest that right now does not require young women to be forced to involve their parents when they do not feel safe doing so. You're absolutely right that we all hope that in the ideal family, a young woman who found herself facing an unintended pregnancy would in fact involve her parent. I hope that my teenage daughter would do that. But I also know that there are many young women in this country and in Illinois who can't do that, who face very serious repercussions if they do. And what we know from research is that those young women who are forced to involve a parent, who don't do so voluntarily, are the ones who are most likely to suffer those negative consequences. Many young women face being kicked out of the house. They fear being beaten by their parents. They've seen this happen to an older sister. We've actually got lots of evidence in our litigation that presents those kinds of circumstances where a young woman, before she is even of childbearing age, witnesses an older sister being thrown out of the house or beaten because she faced an unintended pregnancy. That young woman knows that she can't go to her parents. We also know about young women who fear being coerced into carrying a pregnancy to term that they don't want and that they know is not in their best interest. And these fears of coercion are real. Having a law that forces them to do so is never going to promote healthy communication. And as we know, as I said before, as we know from the research, will subject these young women to negative consequences and dangerous consequences. The research shows, again, that most young women do in fact involve a parent, but where they don't, they often involve another trusted adult, a member of the clergy, an adult sibling, an aunt. They also go through all options counseling when they go to the abortion provider. So they have to be able to give informed consent. They have to be able to understand their risks and benefits and alternatives, and they won't be provided the procedure if they can't do that. And so they are in fact getting guidance. The other thing that we know from states that have mandatory parental involvement laws and have had the judicial bypass process in place for many years is that the vast majority of young women who go through the judicial bypass process are granted a waiver because they are mature enough and well enough informed to make their own decision. They have had a judicial bypass process since 1981, and in that process, 20,000 young women have delayed their abortions and have incurred the burdens of going to court to demonstrate that they should not involve a parent. And out of those 20,000 cases, only 2 judicial waivers have been denied. And the vast majority of the 20,000 petitions have been granted because the young woman was mature enough to make her own decision. And keep in mind that in the Bellotti case, the United States Supreme Court said that where a minor is mature enough to make her own decision, she has the same constitutional right that you and I do to make that decision without involving anyone else.